Thanks, Jess. Thank you. Welcome, everyone. Can I begin with an apology? I've got a bit of a cough. I've just got the tail end of a cold, so if a cough, I do apologise for that. I'll try and keep it to a minimum. What we're going to cover, there's quite a lot to cover, but we'll just give you the background so that you'll understand sort of incorporating. Now, it's aimed at incorporating your practice, but I'm going to have one slide on the 10-year plan because, of course, this incorporation could apply to PCNs as well. We've had a lot of inquiries recently about PCNs incorporating, so it's kind of useful for both. And I see that there's quite a few PCN members who are attending this. We'll explain what a company is, and apologies if you already know this, but we'll give background about what is a company, how it's governed, the governance aspects of it, why incorporate, or rather why consider incorporating. It's not an absolute must for everyone or an absolute perfect answer. It's not a definite you should do this, but it's why do it, and you get an understanding of the options available to you. We'll cover how to do it, how you incorporate a company, and what sort of documentation you need. Particularly in particular for incorporation of practices, this doesn't apply to incorporations for PCN companies, is the commissioner, because in a practice incorporation, of course, the GMS or PMS contract is transferring up. So the commissioner is involved, and we'll look at what the commissioner does in terms of the incorporation of a practice. I'll then hand over to James that will talk about the premises considerations when incorporating, a brief slide on tax and pensions, which is important to consider, and then Q&A, as Jess said. So the 10-year plan, that's my sort of diagram of it. And if you have a look at the sort of right-hand side, you've got practices at the bottom, then a PCN with sort of dotted line around it. And that's really to indicate that PCN is not a legal entity. And then really it's the 3 levels above, which is the 10-year plan. The SNP, which is single neighbourhood provider, and there's a contract coming out, so it'll be the single neighbourhood provider contract, is going to be aimed at a 50,000 population. So that's exactly bang on a PCN footprint. The MNP, multi-neighbourhood provider, 250,000 level, that's at your GP federation level. And there could be whole of ICS contracts, which would require sort of a collaborative. So as I said, we can apply this to the incorporation of a PCN company because the SNP contracts are clearly aimed at PCNs, and we think that the ICB is likely to want a contract with a single legal entity. And therefore, at that SNP level, a PCN, or rather through a PCN company, is the ideal first choice. If they don't go for that, well, another local PCN may go for it, a GP federation could go for it, or a foundation or community trust could go for it. So it's important you look at what's happening with the 10-year plan. But as I say, we're seeing a lot of incorporations for PCN, so this will apply pretty much to that as well. So okay, so what is a company? A company, there's the Companies Act 2006, which is a pretty big act, but it contains everything there is about the establishment and operation of companies and what they can and cannot do. Now, the main point to take away from this is that a company is a separate legal entity. Now, if you think about a practice, everyone talks about the practice as the Exchange Street practice or whatever, as though it was a legal entity. And everyone talks about their PCN as though it was a legal entity, the Harrogate District PCN, whatever it's called. But they're not legal entities. And therefore, in a partnership, it's the partners individually who need to sign on to a lease or any other contract. And within a PCN, it's actually the partners of each of the practices that then need to sign on to the network agreement and any contract. And the principal benefit of having a company is it's a separate legal entity. It's regarded as a legal entity in its own right, and therefore any contract is with the company. Any dealings that anyone has, the employees are employed by the company, and the liability for debts and liabilities of the company sits with the company, not for the individuals. So that's the principal benefit of it. Now, when you're looking at shareholders, now we'll come on to this in a bit, but a company has sort of 3 categories: there's shareholders, directors, and employees. The shareholders own the company. And when you take shares in a company, you get the benefit of limited liability in that the liability of a shareholder is to pay for their shares. Now, normally, when you set up a company, that's usually a nominal sum. You might have 10 £1 shares, so it's £10 that you need to pay. So the shareholder has to pay for their shares, but beyond that, they have no further liability for the debts of the company. So it ring fences the risk into the company, the shareholders who own it, and in an incorporated entity, that would be, say, the partners would become the shareholders holding the shares in the company, and they would have no further liability. Now, there are various types of corporate entities, and you may have heard of these: companies limited by shares, company limited by guarantee, a public limited company, a community interest company, and it's quite confusing. But really, you've effectively only really got two entities: the company limited by shares and the company limited by guarantee. So the difference in them is with a company limited by shares, there are shares. So the company issues shares. There might be 10 shareholders, each holding one share each. So there's 10 shares. And when you become a shareholder, you get given a share certificate to show that you own a share in the company. And as I said before, your contribution is to pay for that share. It might be a £1 share. Once you've paid for that share, you've got no further liability. Now, the company limited by guarantee differs in that it doesn't have shares or shareholders. It has members. And you don't actually take a share or a membership. What you do in a guarantee company is the articles provide that in the event the company is wound up, each of the members will guarantee to pay a sum towards the assets and liabilities of the company. And that sum is usually £1. So each member says, if the company is wound up and it needs to pay off all its creditors and it hasn't been paid through the trading of the company, then yes, I will pay a pound to the company and everyone's pound will be collected together. So that's what the guarantee company is. It's just the method by which somebody says they'll pay the funds. So you don't have shares. It's therefore different in that sense. You have a members list. Now, guarantee companies are usually used for membership organizations like golf clubs or associations. They're not normally commercial. Normally it'd be a company limited by shares because shares are much easier to deal with. You can transfer your shares to somebody else. It's a much easier mechanism. So really, we've got company limited by shares, company limited by guarantee. Now, a public limited company will be one of those, but instead of having limited at its end, it will become a public limited company and have PLC at the end of its name, but it's still effectively a company limited by shares. A public limited company, the difference there is its shares can be issued to the public. So if you want to trade your shares and issue them to the public, you'd apply to become a public limited company. We're not going to discuss it in any detail here today, but there is much more requirement about a public limited company because you're issuing shares to the public. You've got to hold an AGM. There's much more stringent rules around operating that company, etc. So we'll just forget that just now. Now, a community interest company you may well have heard of. Now, a community interest company has got to be a company limited by shares or a company limited by guarantee. So it's back to those two. It must be one of the others. The difference I'll come to in a minute about what a KIC is in terms of the three elements that differ. But effectively, it is a company limited by shares or a company limited by guarantee with three additional bits in its articles. Now, it's often portrayed as a sort of a not-for-profit company, which actually is a misnomer. Every company's got to make as much profit as it can. It's what you do with the profit that matters. It's really more accurate to describe it as a not-for-distribution. So the company may make profits, and the idea is it's a social not-for-profit, as it's normally called, company, which means that the shareholders, the owners of that, don't effectively personally benefit for it. Any profits are rolled back into the community purpose. But we'll come back to that. If you're incorporating your practice, you're probably unlikely to use a KIC. You're probably just be a company limited by shares without it being a KIC. If you're a PCN and it's a PCN incorporation, you may well want to have a KIC, and I'll come back to that in a second. Now, what's really important in all of this is also to consider the eligibility to hold a GMS contract and a PMS agreement. And when you look at the NHS Act of 2006, which has the eligibility criteria for GMS and PMS, only a company limited by shares can hold those contracts. It's the only corporate entity that can hold GMS or PMS, a company limited by shares. So therefore, if you are incorporating your practice, you just don't have a choice. It is a company limited by shares. If you're a PCN company, you've got a choice, but I would always suggest, unless there's a strong reason to do anything else, you would still use a company limited by shares, just in case at some point a PCN company wants to take on a contract of, say, one of its practices, and nobody else wanted to merge with that practice, and the GMS contract would be lost. The company could then take on the contract. So it's a just in case, but I would recommend PCN companies would probably start as a company limited by shares. So, as I've said, a KIC is a company limited by shares, but there's 3 extra elements to it. And those are added in the Articles of Association. 3 additional elements are, first of all, a community benefit or purpose. So it must state in the articles a community benefit or purpose. That is really easy, because effectively your benefit or purpose will be the patients of the population that you're in, either the patients of your practice if it's a practice incorporation, or the patients of the PCN footprint if it's a PCN one. So that's quite easy. It's just you describe the benefit. It's the focus point for the company will be the patient population of whatever locality. The asset lock is, as I've said, to ensure that the assets of the company, if it's wound up, it ceases trading and it's being wound up, don't get distributed to the members. Instead, what happens is you must either identify in your articles another similar asset lock body, i.e. another KIC, or if you don't identify them, then the KIC regulator will choose one for you, so that in the event that companies wound up, the assets are given to another asset locked body. And then finally, there's a dividend cap, and it's important to notice it's not a dividend prohibition. It used to be way back, but it's now a dividend cap. And actually, the cap sits at 35% of your annual profits. So you can, even within a KIC, distribute to the shareholders up to 35% of the profits. Now, you go and have a look at listed PLCs on the stock exchange. You try and find a company that distributes over 35% of its assets each year, you will struggle. So in a way, that's quite generous. So what's the point of a KIC? Well, when it was being considered and it was going through Parliament, there was an intention that a KIC would be a halfway house between a charity and a private company. So that it wouldn't have as many tax breaks as a charity, but it would still have some tax breaks that would make it more efficient than a pure private limited company. The trouble was, halfway through or 3/4 of the way through the process in Parliament, the HM Treasury decided to withdraw those benefits. So frankly, you look at it and think, well, you're not a charity, you're just a company limited by shares. What's the point? Because you've got these additional locks. And the point really is perception. Because commissioners, and this is where it's important, commissioners look at a KIC and think it's a not-for-profit organisation. It's got its community focus. And they might not understand the dividend cap, but they'll think, oh, it's not for profit. You can't distribute profits out to the shareholders. Now you can, subject to the cap of 35%, but they probably don't realise that. So commissioners like KICs, and they think they're safer contracting with them. Now that's not a logical contracting argument, but that's how a lot of ICBs go. So that's why, particularly not so much with an incorporated practice, but with a PCN company, a lot are looking at KICs, and we've had a huge uptick in, as I've said at the beginning, of practices saying PCN, saying we want to incorporate, and saying we want to be a KIC. And just as I said before, the roles in there. So shareholders own, directors are appointed to manage the company on behalf of the shareholders, and the employees work in it. Now, forget employees, not because they're not important, but effectively they just have their contract. This is what you want you to do. This is where you'll work, and we'll pay you this to do it. The real dynamic in the company for you is the shareholders and the directors. Now, in both PCN and practice incorporations, it's usually not an issue, because in a practice, let's say there's 5 partners, they will become 5 shareholders, but they will probably also be the 5 members on the board. And the same people can be shareholder and director and employee all at the same time. You can be a shareholder, a director, an employee. Now, what you need to think of is which cap you're wearing. If you're sat at a shareholders meeting, you must think, I'm a shareholder at this meeting, not a director. And if you're sitting in a directors meeting, you need to think you're a director. But effectively, in these kind of companies, there's not really an issue. It becomes an issue, the distinction between shareholders and directors, if, let's say, there were 40 shareholders and you couldn't have a board of 40, it would be inoperable. So therefore, you appoint a board of 7. So therefore, you're delegating to the directors to run the company, yet you might not have a personal say in that. And then that's when you sort of start to get a distinction between shareholders and directors, and we'll come to how that's addressed in a second. So those are the 3 roles, but the 2 key ones: shareholders own, and the directors manage and operate the company on behalf of the shareholders. In terms of governance, the key document in a company limited by shares is the Articles of Association. So it's the governance document. In a partnership, of course, you'd be thinking about your partnership deed. In your PCN, you'd be looking at your network agreement. In a company, it's the Articles of Association. And this covers the main key bits that are there. It covers the appointment and removal of directors by the shareholders, the delegation to the directors, i.e. how much responsibility is delegated. In most PCN companies and practicing corporations, you just delegate fully to the to the directors, because they are effectively the same as the shareholders. And therefore, there's no need to have a difference. If you've got my scenario that I said you've got 40 shareholders and only 7 directors, then you may delegate most matters, but have matters reserved to the shareholders that says the directors need to come back and get the approval of the shareholders to carry out these things like selling the company or merging it with another company, etc. So that's the first bit that looks at the directors, their appointment, and the delegation of power to them. And then the second main issue is then shares. Are there going to be ordinary shares or what we call alphabet shares, so that you can have somebody holding A shares, then somebody has B shares, somebody has C shares? And the rationale for that is usually you can pay different levels of dividends across different classes of shares, and they can have different rights. So one class of shares might have a right to appoint 2 directors, the other class might have a right to appoint 1 director, if you were looking at maybe a list size basis, but not correlating completely to a list size. And it'll look at share rights around voting and dividends, and the issue and transfer of shares, what are allowed, what transfers are allowed. Because if, for example, you're looking at an incorporation of a practice, then you have a partner who holds a share. If he or she retires, well, you want that share back. You don't want that share to be still held by a retired partner because they're no longer involved in the practice, or you don't want them to be able to transfer the share to a relative or spouse, etc. So you have to deal with issues and transfers of shares as well in the articles. Now, you can also get a shareholders agreement, and the shareholders agreement can cover exactly the same thing, things that go into the articles, but the difference is your articles of association in a company limited by shares must be published at Companies House. So you can go online and look up any company and you can see a copy of its articles. And therefore, sensitive issues you wouldn't want seen. So the difference is a shareholders agreement is private. Nobody gets to see it. It's not published at Companies House. So much of your sort of uncontentious stuff will go in your articles. But if, for example, you wanted a dividend policy and certain rights about how things would be decided, operational issues, you would probably use a shareholders agreement for those. And therefore it would separate those and they would be completely private. Restrictive covenants is another one that usually goes in a shareholders agreement. So they cover the same areas, but you just think, what can we're happy for technically the public to see? Articles of association, if it's confidential and a bit more sensitive, into a shareholders agreement. And then for those who are directors, consider whether they get a service agreement or employment contract. Some have nothing. There's just an agreement that there will be the company will pay the practice, the relevant backfill rate for that partner coming along and being a director and spending time on the company. But sometimes it becomes more developed where you actually put service agreements or an employment contract. A service agreement really is just when the person isn't also an employee. If they're an employee, you just do it in an employment contract. But if they're not going to be an employee, they're just a director, you sometimes have service agreements for directors as well. Governance, statutory duties of directors. So we've said that shareholders are safe and free because once they've paid for their shares, no liability whatsoever. Now, directors have statutory duties all set out in the Companies Act, act within powers, i.e. to act within the Articles of Association. So if the shareholders had had a restriction that the directors couldn't do something and they went ahead and did it, they would be liable to the shareholders for breaching that. They must act within the powers within the articles. The principal duty is the promotion of the success of the company for the benefit of the members as a whole. So the directors must be focusing on making the company as successful as possible, not just for a grouping of shareholders, but for the shareholders and members as a whole. And they must look holistically and not have their own personal interests. But of course, they will have their own personal interests. But that's dealt with in having a decent board of, say, 5 or 6, because everyone's got their own personal interests. But overall, you get a collective decision that sort of smooths all of that out. Directors need to exercise independent judgment. Same point. I'm not thinking about my practice and what will benefit that. I'm back to thinking as a director, what is going to be the best for the success of this company. Must exercise reasonable skill and diligence. There's 2 elements to that, an objective one and a subjective one. So, and the objective one is you must come up to the standard that would be expected of any reasonable director. So you can't sort of put your hands over your ears and say, I didn't hear it, I didn't know, I didn't understand. If a reasonable director would have done something and asked some questions, that's the level you'd be at. There's a subjective one, which is if you are, most of you will be clinicians, of course. So if it's a clinical issue, you'll be expected to have a higher level than of knowledge and understanding than I would if I was on your board as a lawyer. Whereas if it came to a legal or governance issue, I would have a far higher standard on me as a director to identify an issue or to deal with something than any of the clinical directors, because this is out of their normal knowledge. So there's the objective level and the subjective level. Duty to avoid conflicts, and that's dealt with in the articles. Conflicts are everywhere. If you're in a practice and a PCN and a GP provider company, GPs are everywhere. But it's the dealing with them and having the articles contain conflict provisions to ensure that conflicts are declared, and then either that person might be excluded from a decision, etc. And not to accept benefits from third parties, and to declare any interest in a proposed transaction. So if the company is doing a transaction with another company, and one of the directors is also a shareholder or director of that company, that's a connected transaction, and that shareholder should say, that director should say, wait a minute, that company, does everyone know that I'm a shareholder of it and I've got a 5% share, etc. And that's what it means by declaring interest. Not in it's only where you as a director are sitting on the other side of that transaction as well. And then you've got ongoing disclosure. The price you pay as a company for limited liability, i.e. the limited liability of the shareholders, and to a success. Sorry, I didn't finish off. So the directors can be personally liable for breaching those duties and other elements of the Act, but it's very rare. Directors acting properly, it's usually your shysters, it's usually your fraudsters that are caught out. But you can be personally liable, but it's very rare. And acting as a collective board takes away most of the risk of that. And if need, but we provide board training sessions to direct boards of PCNs and incorporated practices if that's of interest. And the price you pay for having the limited liability is disclosure. You must make things public at Companies House, as we've said. So the registrar of companies maintains a register of every company, and you can go online and you'll be able to see, and the company must publish annual accounts. It must publish an annual confirmation statement. Now, the confirmation statement usually just, there's no change. But if you've had a change of shareholders, for example, you would then issue a confirmation. You would put a confirmation statement with a list of the new list of shareholders. And if you're a KIC, you need to prepare an annual report on what the KIC's been doing. The statutory registers are also known as the company books. There's a register of members, register of directors, register of charges, etc. You need to maintain those. Normally, it used to be hard copy paper form. Nowadays, it's usually electronic. And any shareholders entitled to inspect the statutory registers if they need to. Those aren't published at Companies House, but the information's obvious at Companies House, because you can find a list of directors at Companies House and you can see who the shareholders are, etc. But that's a sort of internal sort of set of company books. So why do it? Why think about becoming incorporating either as a practice? And this slide deals with being a practice rather than a PCN. But it's all back to that fundamental point of obtaining limited liability. So if you look on the left-hand side there, you've got a partnership agreement and you've got 4 partners that operate a practice. I've called it the Exchange Medical Practice because I'm in the Exchange building. It's the name of ours. I don't know that there's a medical practice called that. Apologies if there is. And the partners are personally liable to and responsible for everything. The breach of the GMS contract, employment of the employees and any claims by employees, leases and liabilities under the leases, etc., etc., etc. Photocopy your contracts, etc. If you look on the right-hand side, you formed a company. And what that does is that forms a separate legal entity, the Exchange Medical Practice Limited, or that could be the Exchange Medical PCN KIC, whatever. But within there sit the directors running the company, and the employees sit there. And also the contracts and the lease and the liabilities are all with the company. So up above there, you've got your shareholder 1, 2, 3, and 4, and the articles of association governing the running of the company. But once the shareholders have paid for their shares, usually a nominal amount, they have no further liability. Nobody can come to them for anything that the company has done wrong. So liabilities and sit squarely within the company. And the worst case scenario, and you usually wouldn't happen with a GP company or a PCN company, but you find this in commercial companies. The worst case scenario is you just let the company fold. You know, you're running a restaurant and food prices have gone up and cost of living and gas and all that. We can't carry on anymore. We need to wind the company up. Now, the individuals concerned are still not personally liable. So staff have had to be laid off. Some of the creditors have not been paid. Well, that's tough. That's really unfortunate, but that's the whole point of the limited liability company. The creditors lose their money. And they've been made aware of the fact that it's a company, because that's why you have to have limited, and there are certain requirements in the Companies Act that you must make clear in your website and in communications that it's a private limited company. And you might find this because you'll see in the days when you used to get letters, but even email headers now and everything like that, you'd have a trading name of the company, Kleenex or Hempsons. But if you look down at the bottom, there's right down at the bottom of the letter, just a small print down there, and it's Hempsons. And we're actually an LLP, which isn't a corporate. It is a corporate entity, but not a company, limited liability partnership. But it's the same with a company. If we were a company, it would be Hempsons. And then down at the bottom, say Hempsons is the trading name for Hempsons Solicitors Limited or Hempsons Solicitors KIC, whatever, company number blob. And all that's there to say to somebody, look out, we're a limited company. You're dealing with a company. At worst case, you could lose, you could lose from it. Hopefully, it's all good, but that's the whole point. So that's the why do it. The how to do it is quite easy, and I'll just incorporating a company is quite simple. I'll just rattle through this. Well, you apply to Companies House, you send a memorandum of association, which is literally a sort of half a page, which is signed by the initial subscribers, the people that want to set the company up. And they just say, we hereby wish to incorporate a company with the following name, and we agree to take 1 share each or whatever it is. And you sign that. And that's effectively a memorandum of association, basically saying we want to incorporate a company. There's a form IN for incorporation 01, where you put the details of the name of the company type. There's various activity codes if it's a medical company or an engineering company. You must state its registered office, which is an address to which letters would be sent or notifications would be sent. The Articles of Association, there are what's called model articles that are default articles that will apply if you don't adopt any others, and those are perfectly suitable for a general company, not suitable for GP, anything to do with GPs, PCNs, GP federations, because you need to look at the shareholding and the types of people that can hold shares and share transfers, as I've said before. You identify the officers who are the directors, the initial share capital, so it might be 5 shareholders taking 1 share each of £5, so the share capital would be £5 split into 5 shares of £1 each. You need to identify any persons with a significant, beg your pardon. did that by accident. Any persons with significant control, i.e. anyone holding over 25% of the share capital, and there might be in a partnership that has 3 or 4 partners, but usually as it gets a bit larger and in a PCN, nobody has significant control in that way. And you do a statement of compliance. We've complied with the requirements of the Companies Act. You then submit that with a fee, £50 online or £71 paper, and that's processed at Companies House, and you get what is called the Certificate of Incorporation, which is effectively the birth certificate of the company. It has a company number, it shows you what the company number is, and the name of the company, and that's your birth certificate of the company. Now, just an important point if you're looking at companies, companies can change their name, but the company number can never change. So in the days when I used to be a pure corporate finance lawyer, you would get whole kinds of reorganizations. And if you'd be looking at company structures, you'd quite often get companies doing name swaps for various reasons. And this happens a lot. If a company's been trading and it wants to wind up, what it very often does is swap names with a dormant company, so that when it's wound up, it's a funny name that is wound up, and nobody necessarily associates it with the company that it traded as. So if you're looking for a company, always check the company number, because that never changes. That's absolutely unique to the company. You've got the documents. We've already discussed the documents: articles, shareholders agreement, contracts of employment, CQC. Now, if you are incorporating a practice, you then need to, this is very important, you will obviously need a new CQC registration, because CQC has 3 capacities of registrations, or 3 types of registrations: sole practitioners, partnerships, and companies. So you need to move from a partnership registration to a company registration. Now, that's not going to be difficult, given that you're incorporating your practice and you've got a CQC registration there. It's the time factor. 16, 18 weeks, and maybe even more. So you need to plan well ahead. You can sometimes get a comfort letter from CQC that allows you to transition your existing stuff and sort of a fast track saying that, but that usually only comes close to the end. So CQC is an important one to factor in terms of timing. So if you're incorporating your PCN rather than your practice, well, you may not require a CQC. It all depends on who's delivering the registrable services. If you're incorporating your practice, obviously the practice is the company is going to be providing the registrable services, so definitely needs a CQC. If your PCN is going to take on contracts such as a single neighbourhood provider contract and is then going to be providing registrable services, it definitely does need a CQC. If, however, the company secures the contract but subcontracts delivery of it down to the practices, then it doesn't need a CQC contract, CQC registration itself, because it's not delivering the registrable services. And it's very simple, but it's often very confused by people. It's the entity that provides and delivers the services, not the company that owns the contract or the entity that owns the contract, that requires the CQC registration. You'll obviously want to get insurances, but again, your broker that you've dealt with at the practice would be able to deal with that. The difference, the additional, your employer's liability, public liability, and all of those would be there. You might also have D&O cover, which is directors and officers liability insurance. So you would get that to cover liabilities for the directors. And then you come to the transfer itself. Now, this is applicable to a practice that's incorporating, because you then lift the assets and equipment and stock and buildings that James will come to of the practice from the partnership and transfer it into the company. And we use a practice transfer agreement to say effectively there's 2 parties to that, and the one party is the transferors, which is the partners. The other party is the company, and that's the buyer or the recipient transferee. And effectively, it transfers the practice, the equipment, the assets, any goodwill and all of that, lock, stock, and barrel to the company. And as a result of that, TUPE transfer applies, because the staff will automatically transfer into the company as a result of that transfer of the practice as well. You will make the transfer conditional on the ICB agreeing to novate the GMS contract, the assignment of a lease, etc., etc., etc. But that's how it's done. Now, for practice and corporations, just a bit on satisfying the commissioner. So you'll be holding a GMS or PMS contract. and you want to transfer it into a company and transfer everything into a company. Now, the NHS England's Primary Care Policy and Guidance Manual from about 4 years ago provided for practice incorporations, maybe a little longer, maybe it was 6 years. But effectively, there's a section. Now the Policy and Guidance Manual, if you're not aware, it's basically a toolkit for commissioners. So they will look to this if you're incorporating your practice. But it's all available online, so you can look at it as well. And what they have is a sort of medical incorporation template section. And the key bit of this is what's called the CAF, the Commissioner's Assurance Framework. This is effectively a spreadsheet that identifies KLOEs, sorry for the acronyms, key lines of inquiry. And what it does is it takes key lines of inquiry, employees, patients, contracts, all that sort of thing. And it breaks down, well, what is it we want to see? What do we need to be satisfied with? So, okay, the company itself, there'll be a key line of inquiry about the company itself. Is it compliant with the Act, i.e., are all the shareholders going to be GPs or members of the sort of NHS family members, so therefore it's eligible because the shareholding in a company that holds a GMS and PMS has got to satisfy those eligibility criteria. And against each key line of inquiry, they put a RAG rating, that's red, amber, green. And they do that and go through. So what's really useful is if you're thinking about it, you can go and download the Commissioner Assurance Framework in its blank form, and it will have key lines of inquiry. It won't have the detail that the ICB for your particular circumstance would add, but that gives you a really good idea of what they want to see and what kind of things they'll be assessing you against. And you can get ahead of the game and think, right, okay, we'll make sure we've got greens and everything. Right, there's a few orange and one red here. We need to sort that out. How do we do that? Do we do that before we even go to the commissioner? You might go and say, look, we're thinking of incorporating. Would you principle be okay with that? And they come back and say, yes, right, we'll come back to you when we've done the detail, and we'll come back to you in say 3 months time. But then you would do all of this and have that ready, so you make it easier for the commissioner. And then if the commissioner agrees, which they usually do, they prepare a deed of novation to transfer the GMS or PMS from the partnership into the name of the company, and from that point on, the contract is then with the company. Now, there's a standard novation provisions, but you've got to look. They also look at change of control, procurement challenge, personal guarantees. So those are some of the things you'd get into if you're incorporating your practice. So that's me done on the company side, but I'll hand over now to James, who's going to discuss these sort of property aspects for 10 minutes.
Thanks, Ross. So, hi everyone. So again, I'm James Molloy, Senior Associate in the Real Estate team at Hempsons, and I'll be spending about 10 minutes so just to briefly touch on some of the key premises or property considerations on incorporation. So property out of which the practice operates is usually the most valuable asset held by a GP partnership, and how you deal with the property on incorporation depends on the type of property that's held by the practice and where it currently sits, so whether it's held by a separate company or owned by the partners themselves. But for the purposes of today's session, we're just going to assume that the property is held by the partners themselves in the sort of traditional GP partnership model. I think it's important to reiterate, as a reference on the slide there, is that even though the property considerations form part of the overall deal and sort of go hand in hand with the points that Ross mentioned earlier, it has its own legal documents and agreements, etc. So it is a separate transaction, and it needs to be treated as such, and that's where lawyers such as myself come in. So the types of property ownership are freehold and leasehold, and you'll have no doubt heard of those terms before. But just to summarise, freehold is where the land and buildings are owned by the partners outright, so not owned by a third party, and no rent to pay to that third party, although partners will typically receive notional rent under the premises cost directions. And on the face of it, with no third party owner to deal with, a freehold property transfer on incorporation from the owning partners to the new company or new co, it can be a relatively straightforward process, but there are a few things that you need to check. So for example, if there's any third party consent required to transfer the property, so that could be bank consent where the property is subject to a mortgage, or whether another third party has a restriction over the title to protect any positive governance over the land, so for example complying with previous overage provisions. And there will be stamp duty land tax or SDLT payable by NewCo to HMRC on the original transfer. So the amount payable will be on standard commercial rates. So it's payable if the value is over £150,000. Then anything above that, it's assessed on a sliding scale. And so the question of whether it's a more flexible vehicle going forwards, well, once the property is owned by a company, you wouldn't need to deal with individual transfers when partners leave or retire from the partnership. So ultimately, it can reduce admin burden and cost. Unfortunately, it's not uncommon for unincorporated practices to not deal with property transfers on individual partners leaving. So former partners will have left or retired a long time ago in many cases, but their names will still be on the property title. And that can make it tricky to deal with the property, particularly if you're looking to remortgage. So from that perspective, having the sort of one separate entity of NewCo makes it more up to date, and it just makes it easier to manage the property rather than having to deal with 2, 3, 4, or 5 partners at a time. And there's just a point on investment there before I touch on leasehold property. If NewCo's not going to buy the property outright and instead holds it under a new lease, the district valuer and the ICB will need to approve the lease and the rent payable under it before it's entered into. DV approval can take up to a year, so it's always worth having those discussions at the very beginning or as close to as you can, and getting the DV and ICB on board at an early stage to reduce those delays. And you should also remember as well that if a new lease is granted, a new legal interest is created, and so SDLT liability will arise in that circumstance. So leasehold property then, in contrast with freehold, is where the partners don't own the property outright and the freehold owned by a property investor or another third party. So it could be, for example, primary health providers, assurer, or retired partners who still hold a property interest. So property is held for a set period of time under a lease and rent paid, and the terms of the lease will dictate what individual partners can and cannot do with the property. So in terms of the steps for leasehold transfers, one of the main things to check is whether you need the landlord's consent to assign, which is basically just another word for transfer the lease to NewCo. The standard commercial position is that landlord's consent is required, but under most modern GP leases, consent is often not needed, but you would need to check the terms of the lease in question. And the landlord may want additional security as part of the consent process. So that could be a personal guarantee from individual partners, which I will touch on in a second, or a rent deposit, which will require upfront funds and a separate legal document. So one of the main differences is that it's assumed that there's no SDLT liability on the original transfer to NewCo, because any SDLT should have already been paid when the lease was originally entered into. So what you're doing is you're taking a lease of or an assignment of an existing lease, but again, just be mindful that if the original lease term is extended, then that may attract further SDLT liability. And again, in terms of being a more flexible vehicle, well, as I mentioned a second ago, modern GP leases are a bit easier to deal with when it comes to assignments. And again, as with freehold transfers, there's no need to do individual property transfers when individual partners leave once the property sits in NewCo, again, reducing administrative burdens. And there's just another point there about alternative structures. So partners may be permitted in the lease to sublet the property and grant an underlease to NewCo, but the original partners will still remain on the hook to their own landlord under their original lease or the superior lease. And there will be new SDLT liability as well, because again, a new legal interest is being created if an underlease is granted. So this mechanism is best avoided if you can. And then on the next slide is just some wider considerations which will apply whether the property is freehold or leasehold. So if there's a legal charge on the property, you'll need bank consent as mentioned before, or if bank funding is involved, you should involve your bank relationship manager at an early stage, because the bank may have specific requirements. Is the property title up to date, and does it reflect the current ownership? Again, this is something that is often overlooked. So if a partner's left or retired or a new partner joins, then they should be removed from or added to the title as applicable. If the title is not up to date, then that can complicate things, and in particular, it can delay transfers on incorporation. So it is one of the first things that should be checked and routinely checked, and that can be done by a simple search of the land registry. Personal guarantees. Well, if you're being asked for personal guarantees, then that actually undermines the whole notion of limited liability under a company or LLP structure, because an individual is still being asked to give a guarantee personally. So it defeats the object of it, really. So you need to look out for that. And you should at least have an updated valuation report, just to make sure the property or the current value of it is in line with changes to the market. And so sort of the final message is to be aware of the traps. Again, are personal guarantees required, and on what terms? With those, there is a prospect of unlimited liability hanging over you indefinitely. And it's important to make sure that those are released on retirement. Otherwise, you're basically just under an open-ended obligation, and you're putting your personal assets you have at risk. And that doesn't make a partnership attractive to new partners. But remember that whilst the property sits in the partnership as a partnership asset, the practice will benefit from SDLT exemptions upon transfers of that property between partners. Although once the property sits in NewCo, SDLT won't be payable on the change of shareholders anyway. And there may be initial SDLT liability with the property being transferred to NewCo, depending on whether it's freehold or leasehold. But again, at the other end, any transfer out of the NewCo will be subject to SDLT. So that is a brief summary, believe it or not. But just to recap, the property on its own will never be a substantive reason to incorporate by itself. But as we've seen, there are different considerations depending on whether the property is freehold or leasehold. SDLT may be payable on the original transfer if the property is freehold, or if the original lease term increases. You should consider consent required to the original transfer. So bank consent is usually the main one. And make sure the property title is up to date. If not, it should be done at the earliest opportunity. And be mindful that additional security might be needed by a bank or a third-party owner, and consider any requirements for personal guarantees. And there are some further tax considerations, including capital gains, which will be covered in the final couple of slides. And with that, I'll hand back over to Ross, who will touch on those, as well as some general pros and cons of incorporation.
Thanks, James. So, as James mentioned, tax is inherently linked with anything you do here. And you need to we can't advise on tax. We're lawyers, not tax advisors. So working with your accountant or tax advisor on an incorporation is key. Now, just to clarify, NHS pensions used to be complex, but they're not anymore. So in an incorporation, it was never an issue. Company limited by shares holding a GMS or PMS will achieve employing authority status and therefore access to pension scheme. That's not an issue. With PCN companies, it used to be an issue, but that's changed. And if you've got stupid transfer of staff into a PCN company, they will get with closed status access to the pension scheme. So pension's no longer a problem, but tax needs to be considered. Now, not so much a problem, but it just is, there's differences. So James has covered the stamp duty land tax. That tends to not be an issue for an incorporation, because when you're incorporating the company is then going to be providing the services, therefore it's delivering medical services, which are exempt from VAT. So not usually an issue. There can be a VAT issue with a PCN company, because if the PCN, and a lot of PCN companies were formed around sort of ARS staff and housing them. If the PCN company is delivering services, fine. But a lot of them weren't. A lot of them were there to support staff, employ staff, and transfer them back to the practice and provide them. So if you've got a company that is providing support, be it back office functions, finance, etc., and is housing staff, but the actual performance of the death services are being dealt with by practice level, then there's a VAT issue between the company and charging those services to the practices. However, there is what's called a cost-sharing group exemption that enables you to get around that, and that is a common model used. I'm not going to go into detail. If anyone wants to ask, we can deal with that. But effectively, you can, by using that, you can usually avoid the VAT. The main issue on incorporation is understanding the difference in taxation. So, as a partnership, for example, you will have your profits at the end of the year. They'll be calculated and distributed to the partners according to your partnership deed, and then tax is paid at the higher rate tax on those profit shares that each of the partners gets. So you're paying, the higher rate tax on all of that money. The situation in a company is different. So when a company trades, it does pay tax. It pays what's called corporation tax. But corporation tax on its profits is currently between 19 and 25%, depending on the turnover of the company. But effectively, you could effectively have between 19 and 25%. But let's say it's 19. A lot of GP practices would be probably in the lower level. So corporation tax is paid at 19%. Now, if you think about it, if you then keep the remainder of the profits within the company, you've only paid 19% tax, and then that's much better than the partnership. But of course, the whole point in running a partnership is you draw the profits, and therefore, what you would then do would be to dividend the profits out each year by way of a distribution or a dividend out of the company. Now, you then get hit with that income, but it's slightly different, because what the revenue does is recognize that the company has already paid corporation tax on the profits. So it's like a double hit. We're now taxing you. So you don't get taxed at the full higher rate. You get what's called a marginal rate of tax applicable. That's why if you've ever done a self-assessment tax reform, there's a separate section for dividend income, because it's taxed different to your general profit share, which is at your full rate. So there's an important difference there. Now, usually there's no question, because if you're incorporating your practice, you really are then just going to be taking the profits out each year like you do in a partnership. However, if you were a PCN company, then you could think about sheltering the profits within and not distributing out, or when to distribute out. And that's really the key bit, is that switch to corporation tax. Capital gains tax, you get business asset disposal relief in a company, but you get that in a partnership as well. If you retire and you're effectively selling out to retire, then you have a capital gain rather than profits on an in-year basis. You've got your capital accounts coming back to you, etc. And the business asset disposal relief usually reduces capital gains tax from 40% down to about 10%. So just a brief summary of the tax position. It's important to understand the differences, particularly the corporation tax in a company versus you're just taking the profit straight out and you're taxed in your own hands as individuals. And it's important to understand the distinction there. Now, and that's why, going back to what I said at the very beginning, incorporation isn't an absolute panacea for everyone. Go for it. You've got to think carefully about whether it's right for your practice. More so for PCNs, it's usually, I think, not so much of an issue there, because it's specific income that may be going back to the practices, and we may see, I suspect we may see, as I said, that the commissioner or the contract that is produced, the SMP contract, requires a single legal entity to take it. So I think they might push towards a single legal entity and not want to engage with practices, partnerships, PCNs, because they are not a legal entity. There are lots of different people. So that might push towards a company. But so there'll be various reasons and a lot to think about before you make the decision. So there's a summary of the pros and cons. I'm not going to go through that. You can see that when you get the slides. That's just a brief summary of it. And we've got a couple of minutes left for any Q&A. Yeah, Yeah, it's an awful lawyer's answer, but it depends. And what we can't predict is how complex you want your articles, how easy you want your articles. I would have thought a practice incorporation would range between sort of £3.5 and £6,000. But again, it's how many numbers, how many people are involved, and that excludes the property side and what may need to be dealt with there. But for the practice incorporation, that would be a broad ballpark. What was the second part to that, Jess?
It was, do we also need to keep an eye on the impact of the development of neighbourhoods in case the boundaries don't currently align? Yeah,
this is a big issue. It's the donut PCNs as well, isn't it? And there's two issues here. One is PCNs that are not currently aligned because there's a hole in the middle. And the other, of course, which is a much greater issue, is aligning ICB boundaries with local authority boundaries. And I can't answer that because it's too complex and nobody's really, Wesel have got an idea, but everyone's trying to work through the details of that. Whether they change the requirements that are in the DES, because strictly the DES specification and the DES directions state that all of the member practices must be contiguous. They must be touching each other. So you shouldn't have any gaps, but there are plenty that do. And so I think the ICBs will probably continue with let's forget the law and let's look at practicalities, and let's just get, if there's a PCN there and it's not perfectly contiguous, then they might just allow that.
Thank you. It's just going back to the boundaries issues, because we discussed with our ICB and talked about sort of incorporating our PCN. But is it sensible to wait till the SMP contract comes out and till we get all the details, or is it wise to incorporate beforehand? I.e., does it protect us by incorporating beforehand or not?
It's not a question of protection. It's a question of how these contracts will be procured or issued. Now, my concern is, look, as I've said, the IC might say, you need to have a company. We're only going to deal with a corporate entity. And then it's a case of, well, crikey, okay, if we get that contract, how, because you want to win the contract, how do we deal with that? Now, I think the sensible solution would be, you can set up a company in 24 hours quite easily. You can adopt model articles, and in a PCN environment, then it would be relatively straightforward, where you would just say, right, there's 5 practices. Each of the practices will hold 1 share each, and each of the practices will have 1 director on the board. That gets you a very simple, quick model to set up. Now, you haven't thought about issues, should voting be on a list size basis, or should it be on 1 person, 1 vote, and all the stuff you get when you look into the articles. But at least you've got a company in existence with a company number. Because if there's a procurement process that comes out, then you can get in with bidding for that contract and putting a submission in saying, we're a company, here we are, you want a company, here we are, here's a company number. So you can, I think that would be the safest way to do it. Because you then can sort out the setup of the company. It might be a bit messy, and there might need to be a bit of trust. But of course, even if you have a company that it uses model articles and you've not really thought through a lot, if you can secure the contract, which is the key bit, you can then subcontract delivery of that contract to the various member practices. So effectively, you just put it back to where, if the DES funding comes off the back of the GMS contract and goes into the SMP contract, for example, well, you can secure that by winning the contract and then subbing it down to the practices. Now, there's a bit of an overhead in setting up the company, but you can do that. So I wouldn't say you must have a company and roll bells and whistles, but you can use that as a holding point. Now, we should have seen the SMP and MMP contracts by now. They were promised in November. They're not out. My best guess is early January. but they will not be commissioning these until April of next year. So there'll be a time within which you can look, and that's certainly plenty of time for you to then, say January through to March, to set up a company, to work out, incorporate, to sort your articles out and do all of that. So I think you've got the time there. It's unlikely to be, here's the contract, you've got 2 days if you want to apply for it. It's not going to be that. And we will have the buffer with the contract coming out, this sort of template contract coming out, which may or may not be useful. We just don't know what's going to be in it.
Thank you very much.
You can. There's two things here. I mentioned the LLP, which is what Hempsons are, a limited liability partnership. Not to be confused with a limited partnership, which comes from a 1908 Act, and a partnership can be a limited partnership. Now, let's go back to the LLP. This was devised predominantly for large professional firms like accountants and lawyers, because what they wanted was limited liability, but with the ability to still have the tax regime the same, i.e. each individual partner pays the tax on their share of the profits. So think of an LLP as being like a company. It's more like a company than a partnership. It's a corporate vehicle. It's a separate legal entity. It has members. It has, directors, effectively, or officers that run it. But effectively, it's tax transparent, which means that the income coming in to the LLP is not taxed. It's when it is distributed out and the profit share. So each of the partners, now called members, will pay their tax on the profits that they have. So it's a corporate entity, but with tax transparency. There is a Limited Partnership Act of 1908, which not many people know of, but you can have a limited partnership. Now, it is a partnership, not a company. It is a partnership. There must be at least one general partner, and the others can be limited partners. The general partners are still jointly and severally liable for all the debts, as in a traditional partnership. The limited partners have limited liability, which means their liability is limited to the amount they put in, which is usually a nominal amount, and they have limited liability. So they, as a partner, cannot be pursued for the debts and liabilities, provided they do not take part in the management and operation of the practice. So they can't be involved in partnership meetings saying, what we're going to do here, how will we deal with this. The minute they dive into to managing and running the partnership, they become jointly and severally liable. But we use this fairly regularly where we are doing practice acquisitions, particularly where you've got a GP provider federation taking over a practice. You want to keep the partnership and transfer the contract. The ICB won't allow the contract to go directly to the company, to the federation company. So they parachute in a couple of directors who are also GPs. And to begin with, what they do is they'll be limited partners with the existing partners who are the general partners. And there's an agreement in place that they will be retiring at some point in the future, at which point the federation will take over the contract. So that gives the ability for those two federation partners to go on the contract and be on the contract and safeguard the contract, but they'll be limited partners until such time as, whenever it happens, the other two retire off, and at that point they'll become general partners, but they immediately subcontract delivery of the contract to the federation, and the federation's then running it. So we use that method quite a lot, but just bear in mind that distinction between LLPs, limited liability partnerships, and a limited partnership under the 1908 Act.
Yes, hi. Just a very quick question I put in the box. It was just that I've been made aware that to become a company or LLP even, you need ICB approval. Is that right? And if they say no, is there anything you can do about it?
That's correct if you're doing a practice incorporation.
Yeah.
Because they effectively have to approve the novation of the GMS contract from partnership into. Generally, you can challenge. They can. I think they can refuse on certain grounds. So the typical ones: patient safety and financial viability of the entity, etc. But if you have a look at the CAF, the Commissioner Assurance Framework I mentioned, which if you put in NHS England Policy and Guidance Manual, you'll get the Policy and Guidance Manual on a link to that, and you'll find it in an annex to the bit about practice in corporations. There's a section on practice in corporations, and at the end of that section, there's links to various bits, and there's a link to the CAF, and you'll get through to it that way. And if you follow that and comply with that, generally they should be allowing you to incorporate. It became a sort of, not an absolute, but a positive, an expectation that if you fall within the requirements of the CAF and there's no serious concerns, they will allow you to incorporate.
Great. So if we were going to pursue this as a practice, is this a service that Hempson could help give advice about to get that approval?
Certainly, yes, absolutely. It's what we do. We're doing it with PCNs. We're doing it with practice and corporations. And as I say, if it was sort of like, you know, somewhere in Midlands and up, I would up just in London. But you know, we're really one team. We work very, very closely together. So we've got lots of assistants and everything. So we work across the country. But we can certainly help if we can also identify accountants if you don't have an accountant that's really good at primary medical care. We know the ones that are, and we can assist with that as well.
Brilliant. Thank you.
Not at all. Thank you.